Well, Judge, I want to read a statement here that I associate myself with. I certainly don't want you to have to lay out a test here in the abstract, which might determine what your vote or your test would be in a case you have yet to see that may well come before the Supreme Court. Does that sound like a reasonable standard?
Yes, Senator.
That's what Senator Leahy said on July the 21st, 1993. I think it was good then. I think it's good now. You're not a political person, I am, so I want to take a bit of a moment here to talk about the fairness of what's going on in terms of you and Judge Garland. Judge Garland was a fine man. I'm sure I would have voted for him. At the time his nomination came about, we were in the middle of selecting a new president. We're in the last year of President Obama's term. To my Democratic colleagues, I want to remind you of some things that people on your side have said. On June 25th, 1992, it was in an election year. There was a suggestion that maybe one of the judges on the Supreme Court would step down before the election in November. This is what the chairman of this committee, Joe Biden, said about that possibility then. It would be our pragmatic conclusion that once the political season is underway, and it is, action on a Supreme Court nomination must be put off until after the election campaign is over. If someone steps down, I would highly recommend the president not name someone, not send a name up. If Bush did not send someone up, I would ask the Senate to seriously consider. If Bush did send someone up, I would ask the Senate to seriously consider not having a hearing on that nominee. That was Joe Biden, the possibility of a vacancy coming about by somebody stepping down, not dying, once the campaign season was afoot. Justice Alito passed away in February. There had already been 3 primaries. The campaign season, in my view, was afoot. This is what Senator Reid said on May 19th, 2005. The duties of the United States Senator are set forth in the Constitution of the United States. Nowhere in that document does it say the Senate has a duty to give presidential nominee a vote. This is Senator Schumer in the last July 27, 2007. We should reverse the presumption of confirmation. We should not confirm any Bush nominee to the Supreme Court except in extraordinary circumstances. That was the last year of President Bush's last term. To my Democratic colleagues, on November the 21st, 2013, you decided when you were in charge of this body by 52 to 48 vote to change the rules of the United States Senate with the nomination of executive branch appointments and all judges below that of the Supreme Court. I'm not going to ask you whether you think that was fair or not, because that's not your job. I will say to the public, I thought it was incredibly unfair. I thought it was a power grab by our Democratic colleagues that will change the nature of the judiciary for the rest of our lives. Because what you have done is you've made it that you can confirm a judge now within one party if you have over 50 votes, not having the requirement to reach across the aisle to pick up a vote or two, which is a moderating influence. That is lost forever for all judges below the Supreme Court. I was in the Gang of 14 that was formed to deal with the wholesale filibuster of all Bush nominations. New to the body, I felt it would be bad to change 100 and something, almost 200 years, I guess, plus, precedent of how we deal with nominations coming from a president. But there was a wholesale filibuster of everything Bush. And there were 14 of us, I think I'm one of 2 or 3 left, that believed that it was wrong to filibuster Supreme Court judges and judges in general because you don't like the outcome of the election. And we came up with a standard that you should only filibuster in extraordinary circumstances, which I think is consistent with what Hamilton had in mind in terms of the role of the Senate, that you expect a Republican nominee or a Republican president to pick someone different than a Democrat president because that's what the campaigns are all about. qualified judges, and I believe that Sotomayor and Kagan were well within the reasonable mainstream of judges who would be to the left of center in the judicial philosophy world. That's why I voted for them. But now things are different. I believe that that vote, November 21st, 2013, forever changed the way the Senate works when it comes to executive appointments, judicial nominations, and will do long-term damage to the judiciary as a whole, because the most ideological will be rewarded. We don't have that requirement yet for the Supreme Court, and I hope we never will. Time will tell. I'm not optimistic. At the time of that vote, the Senate had confirmed 19 of the President Obama's judicial nominations. That same time in President Bush's second term, there had been 4 confirmed. I thought it was a manufactured crisis. I thought it was politically motivated. And when it comes to cries of being unfair, they fall on deaf ears. As to Justice Garland, fine man. I fully expected Trump to lose. He won. I think he deserves the right of every president to pick qualified people. And that's just not me saying that. This is what the Federalist Papers number 76 said about the requirement of advice and consent. This is what Mr. Hamilton wrote a very long time ago, in 1788. The Senate could not be tempted by the preference they might feel to another to reject the one proposed, because they could not assure themselves that the person they might wish would be brought forward by a second or by any subsequent nomination. They could not even be certain that a future nomination would present a candidate in any degree more acceptable to them. To what purpose, then, require the cooperation of the Senate? It would be an excellent check upon a spirit of favoritism in the president. It would tend greatly to prevent the appointment of unfit characters from state prejudice, from family connection, from personal attachment, or from a view to popularity. That was the check and balance, advise and consent rules of the game that were established in 1788. When you look at the history of the Senate's role in confirming justices to the Supreme Court, it has changed dramatically. Many of the judges of the Supreme Court were confirmed without a hearing, some without even a recorded vote. I'm not here to say that my party is without fault in the area of judges. We're not. I'm here to say that on 2013, in November 2013, the game changed in a way that I think Mr. Hamilton would be very disappointed in. And it's not that I don't understand. I very much do. When my time came for Sotomayor and Kagan to appear before this committee, I knew what awaited me if I applied the Hamilton standard. Partisan people abound on both sides of the aisle. The ferocity by which people wanted me to vote no was real, apparent, and I could feel it. I believed that if Strom Thurmond could vote for Ginsburg and that 98 senators could vote for Scalia, that there was a point in time where it was expected that you would vote for somebody you would not have chosen. You would use the qualifications of that person. So we find ourselves here today confronting a nomination of one of the most qualified people I think President Trump could have chosen from the conservative world. You are not an unfit person. I don't think there's any reason to suggest that you're his favorite. Had you ever met President Trump personally?
Not until my interview.
In that interview, did he ever ask you to overrule Roe v. Wade?
No, Senator.
What would he have done if he'd asked?
Senator, I would have walked out the door. It's not what judges do.
Okay.
They don't do it at that end of Pennsylvania Avenue, and they shouldn't do it at this end either, respectfully.
This is what the speaker, the Democratic leader in the House said about you. Neil Gorsuch is a very hostile appointment and a very bad decision, well outside the mainstream of American legal thought. If you breathe air, drink water, eat food, take medicine, or in any other way interact with the courts, this is a very bad decision. I want to ask you to respond to what I think is complete, absolute political garbage. And statements like that were also directed against Justice Sotomayor and Kagan. I remember Sotomayor being called a racist because she gave a speech that was edgy. I remember Elena Kagan being called unpatriotic because she was involved in the decision at Harvard to kick the ROTC unit off the campus. And the reason I didn't buy one was a racist and the other was unpatriotic is because I took the time to look at the way they lived their lives, and I listened to what people had to say who had interacted with them all their lives. To my Democratic colleagues, if you take the time to listen to people who have interacted with Judge Gorsuch throughout his entire career, you will find pretty quickly that he's a fine, decent man who has tried to be a good father, a good husband, a good lawyer, and a good judge. And if you don't want to take the time, it says more about you than him. All I can say is it is impossible to conclude that what Nancy Pelosi said about you is anything other than political talk because there are no facts to justify that. The ABA gave you the most highly qualified rating they could give anybody. I just want you to know that I believe you have led a life you should be proud of, that you've tried your best to be a good father, a good husband, a good lawyer, and a good judge. Now, let's talk about our interaction a long time ago.
Thank you, Senator, for those very kind words.
Well, it's something you've earned, not something that you need to thank me for. The bottom line is, are we at war in your view as a nation?
Senator, all I know is that there are a lot of young men and women out there in harm's way so that we may sit here and have this conversation.
It would be news to them we're not at war.
I'm sure that's right.
Yeah, it'd be news to the families who've lost a loved one in this fight. So I think we're at war. Would you agree with me it's not a traditional war?
Certainly not, Senator.
There is no capital to conquer, no Air Force to shoot down, and no Navy to sink. There is no taking of Berlin and Japan. Do you agree with me it'd be hard to determine when the war is actually over?
Senator, that was a question that the court struggled with in the Hamdi case, as you know.
And we had a lot of conversations about how to proceed forward when you were in the Bush administration. Is that correct?
We did.
And you were in the camp of the Youngstown Steel camp, that if Congress is involved, the president is stronger, not weaker. Is that right?
That's right, Senator.
But there are some authorities that the president as commander-in-chief have that cannot be taken away by the Congress. They're inherent to the job. Is that true also?
There's certainly people who believe that, Senator.
Well, I am one of them. But having said that, because you can't have 535 commander-in-chiefs, Senator McCain and myself were trying to pass legislation that basically codified the practices of the Bush administration post-waterboarding. Is that a fair summary of the conflict?
Yes, Senator, I believe it is.
There were people in the Bush administration who did not want to go down the road that waterboarding was torture. That was not the view of Senator McCain or myself. At the end of the day, the Detainee Treatment Act codified how we treat enemy combatants in a time of war in terms of what practices we can employ in terms of interrogation standards. Is that correct?
Yes.
And it also tried to come up with a system of judicial review. I was in the camp that were at war, and in past wars, you don't give enemy prisoners lawyers. I don't remember any German or Japanese prisoner having a lawyer when they were captured. So traditionally, is it the commander-in-chief's job to determine who the enemy force is?
There's certainly legal authority suggesting that, Senator.
And this court's job to determine if the procedures in question pass muster?
That's correct, Senator. And of course, this body plays a role too.
So the dilemma was that I believed it was the Department of Defense, the commander-in-chief's job to determine the enemy force because that's their expertise. And Congress could regulate the naval and land forces, and we had a say about how they could do that. And the courts have a say as to whether or not the procedures used by the President of Congress pass constitutional muster. Is that the general layout of this situation?
That's the separation of powers at work.
And there was a cross current here. There was an email that you weren't part of. You were not included on the email, but it says, Neil and I have just been told separately, this is not what the White House wants. We have been given authorization to engage on the Graham Amendment, and not just authorization. They want us to engage, to eliminate if possible, but if not, to fix. DOD, not DOJ, has the lead, which may be what led to DOJ-LA's confusion. But the key point for us is that we have green light to engage on Graham. And what I was trying to do was preserve the Combat Status Review Tribunal concept, the ARB, Administrative Review Board concept, and allow the courts to judge the work product at the D.C. Circuit Court of Appeals, to have judicial review, but let the CSRT go first. Do you remember that debate?
I do.
Okay. And it was settled in the Congress where the Combat Status Review Tribunal would have the first shot at determining whether somebody's an enemy combatant, and the D.C. Circuit Court of Appeals could review their work product to see if it was capricious or arbitrary, if it made sense. The Supreme Court in Boumediene struck that down, saying it was not an adequate substitute for habeas. Is that correct?
That's absolutely correct, Senator.
And your role in all this was try to find out a way to engage Congress on the Detainee Treatment Act because it was your view that Congress being involved would strengthen the president's hand.
As a lawyer,
Yes.
I was not a policymaker, but I did advise.
As a lawyer.
As did many others. There were many other very fine lawyers too, Senator, who advised the administration that engaging Congress would be a good idea because we had read our Youngstown and our Justice Jackson.
Any lawyer, I think, who understands this area of the law would suggest the president's stronger when he has congressional support. The signing statement. Is it fair to say there was a conflict between the vice president's office and other parts of the Bush administration about what this signing statement should say or look like?
That's my recollection, and that's about all I can recall.
I remember it very well because Vice President Cheney's signing statement was going to be, we have an inherent authority to do whatever we think we need to do. And there were a lot of other people saying, no, you don't have the authority just to set aside a law. You have to have a reason to object to it. So I just want the public to understand that when it comes to this man, I've seen him in action in very complicated emotional matters where he had one group of people who could give a damn about the terrorist and another group of people that wanted to criminalize what I thought was a real-world fight. And we tried to find that middle ground. And in a 5-4 decision, the Supreme Court struck down my proposal, and we fixed it later with a huge bipartisan vote so that every enemy combatant today has a habeas proceeding where the government has to prove by preponderance of the evidence you're in fact an enemy combatant. Then if they reach that conclusion, you can be held under the law of war as long as you're a threat to our nation. Is that a fair summary of where we're at?
That's my understanding, Senator. Along the way, your legislation did prevail in the D.C. Circuit and in the Supreme Court. Of course, it was a close call. It was 5-4, as I recall.
And that just proves that 5 people can be wrong. So, well, I disagree. I certainly respect the court's decision.
You're not going to get me to commit on that one
don't
either,
worry. I'm
Senator.
not even gonna try. The bottom line here is there will be more legislation coming regarding the role of the government in gathering information. But from sort of a civics point of view, which Senator Sass is going to take you through, there's a difference between the law of war and domestic criminal law. Do you agree with that?
Yes, Senator.
That a common criminal, the goal of the law is to prosecute a crime that one individual or group committed against another individual or groups. That's correct?
That's right.
The law of war is about winning the war.
Well, Senator, there are
How you fight the war.
there are, as you know, rules about that too.
Right.
Laws about that.
Yeah, and we're fighting an enemy who has no rules, that would do anything, and I've always been in the camp that I don't want to be like them. I think that's their weakness, and the strongest thing we could do is stand up for a process that stood the test of time, which is intelligence gathering in a humane way, because they would cut our heads off. Doesn't make us weak because we won't cut their heads off. It actually makes us stronger over the arc of time, so that's my commercial about that. So there will be more litigation, and there are no bad guys or girls when it comes to challenging precedent. Do you agree with that? People have the right to do that.
To challenge precedent?
Yes.
Every person is allowed to come to court to bring whatever claim they have. That's how our system
That's how
works.
Brown versus Board of Education came about.
Exactly right, Senator.
Okay, let's talk about Roe v. Wade. What is the holding of Roe v. Wade in 30 seconds?
Well, the holding of Roe versus Wade in 30 seconds, Senator, is that a woman has a right to an abortion. It developed a trimester scheme in Roe that specified when the state interest and when the women's interests tend to prevail.
Okay, so let me just break it down. The court said that there's a right to privacy, that the government can't interfere with that right in the first trimester. Beyond the first trimester, the government has more interest as the baby develops. Is that fair to say?
That was the scheme set
And I
forth.
think medical viability was the test that the court used.
Well, that's the test that the court came around and applied in Casey in 1992.
Okay.
And so viability became more of the touchstone rather than a rigid.
Is it
trimester.
fair to say that medical viability in 1992 may be different than it is in 2022 medically?
Senator, I'm not a scientist or a doctor.
I would suggest that medical viability may change as science progresses. So you may have people coming in and saying, in light of scientific medical changes, let's look at when medical viability occurs. That's one example of litigation that may come before you. I have legislation that says at 20 weeks, the unborn child is able to feel excruciating pain, and the theory of the legislation is that the state has a compelling interest to protect an unborn child from excruciating pain, which is caused by an abortion. I'm not asking you to agree with my legislation. I am saying that I am developing, we're one of 7 nations that allow wholesale, on-demand, unlimited abortion at 20 weeks, the 5th month of pregnancy. I'd like to get out of that club, but we're going to have a debate in this body, in the House, about whether or not we want to change the law to give an unborn child protection against excruciating pain at 20 weeks, because you can, the standard medically is that if you operate an unborn child at 20 weeks, the medical protocols are such that you have to provide anesthesia because you don't want to hurt the child in the process of trying to save the child. So medical practice is such that when you operate an unborn child at 20 weeks, which you can do, you have to provide anesthesia. And my theory is, well, let's just look at it the other way. Should you allow an abortion on demand of a child that can feel excruciating pain? Is that what we want to be as a nation? Does that run afoul of Roe v. Wade? I'm going to make the argument that there's a compelling state interest at that stage of the pregnancy to protect the child against death that is going to be excruciatingly painful. You don't have to say a word. I'm just letting everybody know that if this legislation passes, it will be challenged before you. And you'll have to look at a new theory of how the state could protect the unborn. And here's what I think. You'll read the briefs, look at the facts, and make a decision. Am I fair to conclude that?
Senator, I can promise you no more than that, and I guarantee you no less than that, in every single case that comes before
Well, this
me,
is a
no matter
real-world
what the subject
situation
matter.
that may develop over time because 70-something% of the American people side with me on the idea that at 20 weeks, we should not be in the club of 7 nations that allow abortion on demand, because that's in the 5th month, and that doesn't make us a better nation. There'll be people on the other side saying, no, that's an erosion of Roe, and it will go to the court, maybe, if it ever passes here. And the only reason I mention this is that everybody who wants to challenge whatever in court deserves a person like you. A person like you, no matter what pressures are applied to you, will say over and over again, I want to hear what both sides have to say. I want to read their legal arguments, look at the facts, and I will decide. That, to me, is reassuring. And that's exactly the same answer I got from Sotomayor and Kagan. No more, no less. And we can talk forever about what you may or may not do. If you do anything different than that, I think you'd be unworthy of the job. Now, about what's going on in the country with President Trump. Whether you like him or you don't, he is president. But you have said several times that he is not above the law as president. Is that correct?
Yes, Senator.
You told Senator Leahy if there was a law passed that a Muslim could not serve in the military, you believe, based on current law, that would be an illegal act.
Senator, yes, I see that having all sorts of constitutional problems under current law.
So if we have laws on the book that prevent waterboarding, do you agree with me that the Detainee Treatment Act prevents waterboarding?
Yes, Senator, that's my recollection of it firmly.
So in case President Trump is watching, which it may very well be, one, you did a good job picking Judge Gorsuch. Number two, here's the bad part. If you start waterboarding people, you may get impeached. Is that a fair summary?
Senator, the impeachment power belongs to this body.
Okay, that's even better. Would he be subject to prosecution?
Senator, I'm not going to speculate.
But he's not above the law.
No man is above the law.
Okay.
No man.
Thank you. I think you're a man of the law, and I really want to congratulate the president to pick you. Quite frankly, I was worried about who he'd pick. Maybe somebody on TV. But President Trump could not have done better in choosing you. And I hope people on the other side will understand that you may not like him. I certainly didn't agree with President Obama, but I understood why he picked Sotomayor and Kagan. And I hope you can understand why President Trump picked Neil Gorsuch. I hope you'll be happy with that, because I am.